Thank you for attending Implementing Issue 2, Criminal Justice Reform After Marijuana Legalization. The event is hosted by the Drug Enforcement and Policy Center at The Ohio State University Moritz College of Law. Before we begin, we have just a few notes we'd like to share with you. First, we want to draw your attention to the Q&A function at the bottom of the Zoom window. The chat is disabled, but you may submit questions at any time. Please note, however, that there is typically limited time available for Q&A during the webinar. Second, automatic closed captioning has been enabled for the event. To change how you view the transcription or to hide it, you'll click Show Caption in the menu at the bottom of the Zoom window. Finally, this event is being recorded. The recording will be made available on our YouTube channel as soon as possible following the event. A link will be shared with all registrants via email as soon as it is available. Follow us at OSU Law DEPC to stay up to date on our research, programming, and future events. Thank you again for joining us, and we hope you enjoy the discussion. Doug?
Thank you, Holly, and thanks to all of you joining us online, and thanks in advance to our panelists who are going to be talking about the, I think, evergreen issue of the relationship between marijuana reform and criminal justice reform. And introduce myself, I am Doug Berman, a professor here at The Ohio State University Moritz College of Law, and also the director of the Drug Enforcement and Policy Center. And in many respects, I started the center because I found this story of how marijuana reform will or will not end up impacting broader criminal justice reform movements so interesting and so challenging and so dynamic. And that's been something that our center has worked on in a variety of ways for a number of years. And at the same time, marijuana reform was coming to, in a sense, our back door. As some of you are probably familiar with, last November, Ohio voters enacted with a fairly significant yes vote, 57%, for cannabis legalization, full legalization in the state. We've had a legislatively created medical marijuana program for a number of years, but now we are a full adult use state. That law became effective in December. However, as the proponents of the initiative explained, they chose not to include any significant criminal justice reform in the initiative, even though a number of other states have included that in legislation or initiative efforts. They said concerned about a single subject rule problems. That's Ohio's law that says a law can only be on one subject. Debatable whether this is not obviously all part of one subject, thinking about legalization of what had been criminalized and doing broader reforms, but the concern was that it might not be viewed that way. And so as a result, we got enactment of a law, issue 2, that has, in a sense, some recommendations and some directives and some tax revenues devoted to looking at criminal justice issues, but not a tangible set of criminal justice reform proposals, notwithstanding that that's become a quite integral part of reform efforts. And here I want to flag a recent paper that very recent, literally just came out yesterday, that our center has done, particular thanks to DEPC's Yana Herndova and Dexter Ridgway, where they've produced a paper that's called Mapping Cannabis Social Equity, Understanding How Ohio Compares to Other States' Post-Legalization Policies to Redress Past Harms. That paper looks at social equity issues in cannabis reform more broadly than just, and thanks to Holly for putting the link in the chat, that looks to social equity issues more broadly than just criminal justice reform, but record sealing, record relief, expungement, and a range of issues, resentencing connected to criminal justice reform have been also a really robust part of cannabis reform and regulation in recent years, and that's one part of their paper. And we thought it would be valuable to bring some experts together to talk about this story with some of the national landscape in place, but then also to really try to drill into the specifics in Ohio, both the potential for, the likelihood for getting some follow-up legislation that includes direct criminal justice reform, and some of the implementation challenges and issues that these efforts necessarily create. So with that background and sort of table setting, I want to introduce very quickly our 4 panelists. The way we talked about operationalizing our conversation is, after my introduction of all 4, I'll tap on one of them to do somewhere in the neighborhood of 5 to 8 minutes of opening remarks to discuss their perspective on these sets of issues, and then we'll follow up with some conversation. I'll have some questions. I believe that you can bring some questions into the Q&A that I'll try to integrate into our conversation. And I am very confident we'll all be more informed by the end, though I'm also very confident we won't have everything figured out for sure. So with that, let me introduce our four panelists who I'm grateful are joining us today. We have Adrian Roca. I'm introducing them in the order that they're going to speak, from the Last Prisoner Project. We have Daniel Dew from the Adams Project. We have Louis Tobin from the Ohio Prosecuting Attorneys Association, and we have Representative Juanita Brandt from the Ohio General Assembly. I gave just the very basic introduction of who's speaking because I hope they'll talk a little bit about their background and how they come at this issue of the intersection of cannabis, marijuana reform, and criminal justice reform as part of their opening remarks. And so with that, I now am going to tap Adrian from Last Prisoner Project. They'll also encourage all the panelists to turn their cameras on so that we can now get the opening remarks and then start a broader conversation. Thank you very much again, panelists, and Adrian, the floor is yours.
Well, thank you so much, Doug, for that introduction, and great appreciation to the Drug Enforcement Policy Center at The Ohio State, I believe I articulated that correctly, for inviting us to be a part of this panel today. As Doug mentioned, my name is Adrian Rocha. I'm the policy manager for the Last Prisoner Project. We're a national nonprofit that works specifically at the intersection of drug policy and criminal justice reform. So our lens has really been on emphasizing the idea of retroactive relief for individuals. So as a state legalizes, the concept should be that justice isn't merely achieved in building a marketplace for cannabis, but in undoing what has caused or what the harms that prohibition caused as part of that process. So I just want to provide a sort of general overview of how we approach this conversation and where Ohio fits in it. So to date, 24 states have enacted cannabis-specific record clearance laws as part of their legalization, and 10 states have enacted cannabis-specific resentencing laws. So we have a really great report that's available on our website that I'll plug here for folks to check out. The voters of Ohio actually made our report outdated by 2 months afterwards when they voted to legalize issue 2 on that. So apologies for that asterisk. We will update that. Importantly, these criminal justice policies have become incredibly more commonplace in recent legislation. In fact, since 2018, 100% of the 13 states that have legalized cannabis have included record clearance policies. And since 2021, they've all been state initiated. And I'm sure we'll spend some time on the concept of what state initiated resentence or record clearance means. While resentencing policies have been a little bit slower to take hold nationally, they're also growing in importance and recognition and have been included in at least half a legalization bill since 2020. That's all to say that Ohio is a bit of an outlier in that issue 2 did not contain either of these provisions for reasons that Doug mentioned, part of the single issue concept in the ballot initiative there. Nevertheless, anytime a state considers legalizing adult use cannabis, it represents a significant step in the right direction by ending these types of prohibition policies that have derailed countless lives for a plant that was once listed in the Sears Roebuck catalog. So what we really want to see is that any path towards legalization post issue 2 that seeks to build a new marketplace must also commit to dismantling the injustices perpetuated by prohibition policies. Ohio must ensure both that state-initiated record clearance and resentencing or individuals who are currently serving for cannabis-related sentences have an opportunity to see their sentences reconsidered in light of legalization. So in sum, I would really say that issue 2 has made prohibition a part of Ohio's past, but addressing the harms perpetuated that policy have not been corrected or ameliorated.
Thank you, Adrian, and very efficient. I appreciate that as well. So we'll have all that much more time for questions and follow-up. But now we'll turn to Daniel Dew of the Adams Project.
Thank you so much. Thank you to DEPC for putting this on and talking about this really important issue. I'm with the Adams Project. Previously, I was with the Buckeye Institute. I chaired the Ohio State Bar Association's Criminal Justice Task Force. And at the Adams Project, we really look at criminal justice issues through a conservative lens, making sure that there's accountability, there's due process, that we're supporting law enforcement, and that there's rehabilitation. And obviously, this falls under the rehabilitation portion of our portfolio. And so Ohio actually has a pretty good history with record sealing as far as which offenses are eligible. Ever since I've been involved with working with Ohio legislators, there's been a real focus on how do we help these people? How do we get people back to work if you look at recidivism, one of the best indicators of whether somebody's going to recidivate is if they have a job. We think about putting people on probation and things, but actually a job is the best probation you can get. It's something that people have to show up for regularly. They have to be in a condition to work. And so the record sealing is really about making sure that people aren't unfairly limited in job prospects, where they can live and such things. I remember years ago, a close friend of mine was just getting ready to graduate. He was getting a degree that would allow him to work at a power plant, and he was newly married. His wife was newly pregnant, and he came to me, pulled me aside with tears in his eyes, saying, "I just found out that I'm not going to be able to get a job because it turned out that he had a marijuana possession record from a few years before that." And luckily, I was able to work to help him out. He had a friend that had filed in courts before, and so we were able to figure it out and get his record sealed, and so he was able to get a job. But a lot of people aren't so lucky. So, back in 2018, Ohio passed Senate Bill 66, which did a great job of expanding which offenses were eligible for record sealing. It made it so that more offenses could be sealed. As far as numbers of previous convictions, it set good timelines for so many years after the conviction that they were able to receive relief. And then in just this last session, there was Senate Bill 288 that again that was part of a larger criminal justice package, looking at record sealing, and eliminated some of even the higher limits that SB 66 had pushed for record sealing. So I think that Ohio is actually in a pretty good place with the number of records that are eligible for sealing, with what offenses and everything. The problem is it's a hard process to go through. When I was working with my friend, even though I was an attorney and had filed in different contexts, it took some real work to make sure that I used the magic words on our application, dotted our I's, crossed all of our T's to make it work. And so I think that's the real barrier here is how do we make this process easier for people so that they're not limited in where they can work, where they can live, especially in light of the fact that Ohio no longer considers marijuana possession a crime.
Wonderful. Thank you, Daniel. I appreciate that. And, both you and Adrian have started to frame an issue that we'll certainly follow up on, which is, especially when we're focused on record relief, expungement, sealing, whichever term or remedy is being used, there's an eligibility question: who's eligible to get this relief? And then there's that process question, and then the practicality of, does the process enable folks to do it? And one fairly recent development in Ohio, and maybe Lou, don't want to force you to talk about this. I want you to talk about what you want to talk about, but Ohio has been trying out the idea of prosecutor initiated record sealing and expungement, which hadn't been available until a relatively recent bill. But even before that, my understanding of Ohio's process has always been that prosecutors would have an opportunity to weigh in on a record sealing application or the process regardless. And so, very grateful to have you here, Lou, to sort of talk about, from a prosecutor's perspective, both, the broader story in Ohio with respect to record relief processes, and then especially, how we should be responding to the legalization of marijuana and its intersection with these issues. So without further ado, go ahead, Lou.
Thank you. And thanks to Professor Berman and the Ohio State Law School for including us in this conversation. Always appreciate being invited, and I think probably providing a bit of a counter point of view to some of the other panelists on here. Just so everybody knows a little bit about our association, we are a statewide association for county elected prosecutors in Ohio. All 88 elected county prosecutors are members of the association, and there are about 1,500 or so assistant prosecutors who are also considered ancillary members. We come at these issues obviously from a law enforcement perspective and a public safety perspective. And I think one of the things that I would push back on just a little bit immediately that Dan said, that we've decriminalized the possession of marijuana. We've decriminalized possession of small amounts of marijuana. The way that issue 2 operates, it basically creates a zone of immunity as long as you're engaged in certain behaviors that are outlined in the statutory language of issue 2. And that means you can possess up to 2.5 ounces of marijuana. People who fall outside that zone of immunity are still going to be in violation of Chapter 2925 and potentially subject to criminal drug possession charges and criminal drug trafficking charges. So, issue 2 didn't create some free market marijuana paradise in Ohio. It created a limited marketplace where people can buy, possess, and use small amounts of marijuana. I do agree with Dan that I think Ohio has already gone, I mean, quite frankly, from our perspective, I think has gone overboard in terms of what we allow for record sealing and record expungement. Record sealing and record expungement used to be relief for first and maybe second time offenders who had made mistakes and who deserved an opportunity for a second chance. And I think, quite frankly, we supported giving people second chances. Now, after Senate Bill 66 and Senate Bill 288, people can seal an unlimited number of misdemeanors, an unlimited number of felony 4 and felony 5 nonviolent, non-sex offense crimes. They can seal up to 2 felony 3 offenses. I haven't studied what other states have done. Maybe Dan or Adrian can comment on this more, but my sense is that Ohio probably already has one of the most liberal, if not the most liberal, record sealing, record expungement schemes in the United States. The issue that presents for prosecutors is that we have people who come back in front of us charged with new offenses. We know they've been there before. We know they've been convicted of before, but now their records have been sealed. And, maybe a year later, they're going to have records of this new conviction sealed too. And so I think we've just gotten a little bit away from what the original policy goals of record sealing were, to provide people who had made a mistake with a second chance. The other thing I would push back on a little bit is this idea that we need more record sealing or sentencing relief because of issue 2. One of our current records, our current record sealing law allows people who are convicted of a minor misdemeanor to apply for record sealing and record expungement 6 months after the end of their sentence. So somebody who's convicted of possession of up to 2.5 ounces of marijuana is already going to be able to have their record sealed or expunged after 6 months. So I think the idea that we need to do something additional because of issue 2 is just not necessary. I don't want to take up too much more time, Doug, but you'd asked me to talk about some of the challenges for prosecutors because of issue 2. You want me to do that now, or?
Yeah, sure. We've got time, and certainly focus on the process, because I think that's exactly where whatever the lay of the land ends up being in response to issue 2, prosecutors are going to have a voice in general and a voice in individual cases, and curious or eager to hear your take on how it creates challenges potentially for your association and
okay. Yeah, and so I think that the challenges that prosecutors face because of issue 2 are the thing that's most important to us is the black market and keeping the black market under control. There are going to be problems with road safety and highway safety. This is more of a public health issue, but we're also concerned with underage use and accidental ingestion by children, and then just general drug interdiction efforts. And maybe Representative Brent might talk about what's going on in the legislature too, but there are kind of competing views right now between the House and the Senate about what they need to change as a result of issue 2, how much they need to change, and the urgency of that. the Senate has passed a series of changes that, quite frankly, I think we are largely supportive of. We think the Senate did a good job of kind of respecting the fact that voters voted to to make it possible for people to possess, use, and purchase small amounts of marijuana. And I think some of these other ancillary issues in issue 2, I think while voters might have liked those things, I think at the end of the day, they were voting to legalize small amounts of the possession of small amounts of marijuana. And so I think the Senate kind of did a good job of reeling in some of these ancillary issues in issue 2 while keeping the heart of the issue intact. The House, I think, has a little bit of a different view. I think they're more reluctant to make changes to what people voted on. And I think they don't feel quite the sense of urgency. I think just in terms of our primary concern, which is keeping the black market under control, we would agree with the Senate and the governor that there is more urgency here. I think we would like to see the House take action on something sooner rather than later. The black market, I think other states that have legalized marijuana have experienced a growth in the black market and a thriving black market. And really the driving forces behind that are, one, that the black market is always going to outprice a regulated market. I think there are going to be a lot of people who say, look, I can go to a dispensary and I can buy marijuana, an ounce of marijuana for $100, or I can go to this guy I know down the street and I can buy an ounce of marijuana for $50, and they're going to go to the guy down the street. And it also just prevents huge problems for not only marijuana interdiction, but drug interdiction in general, because you've got, and in particular in issue 2, you're allowed to grow 6 plants if you're one adult. If you've got 2 adults in a household, you're allowed to grow up to 12 plants. You're allowed to transfer those plants. You're allowed to buy up to 2.5 ounces per day. So you can buy 2.5 ounces today, tomorrow, Friday, Saturday, and Sunday, and you can transfer those or stockpile those too. So those are just some of the things that we think need to be reeled in, because we want to respect what the voters did, but we have a responsibility to larger public safety as well.
Very good, Lou. I appreciate that, and thanks for expounding on a number of those points. And I'll actually quote for sort of a broader conversation in a minute some of the language from issue 2, and then the ongoing debate that surrounds both record sealing and then some broader issues related to criminal justice. But first, I want to make sure Representative Juanita Brent, it's her chance to talk about what she's seeing and the work that she's doing in this context. We just heard from Lou Tobin about ongoing debate within the General Assembly. The Senate's already passed reforms. My understanding is not just you, but many members of the House aren't so keen on what has been suggested from the Senate, but I think that included at least some expungement provisions as well. And so it did hit on some of the topics we're focused on here. But my sense is you've really been a leader, Representative Brent, on a range of social equity issues, and have spoken out about how important it is to lean into these issues as the General Assembly considers its response to the passage of issue 2. And so with that background, eager to give you an opportunity to talk about the work that you're doing, and also perhaps giving us a little bit of a forecast of when we might expect the House to move forward on some of these fronts, because there's this ongoing debate in the state as well about not just what the reforms should be from the General Assembly, but what the pace needs to be. And so with that, thank you again for joining us and taking time to share your important perspective. And so the floor is now yours.
Thank you so much, Professor, and for the Ohio State University, for building this Zoom, this space of convenience that we could all be able to share and learn more about what adult use cannabis will be here. Well, what adult use cannabis is now and what it will be going on in the near future. For those who don't know, I'm originally born and raised right here in the Cleveland area. I represent part of Cleveland in the northeast portion of the state. And the entire time I've been here in the General Assembly, I've introduced multiple bills that have been about expanding the use of cannabis. I have been a huge proponent because we could not keep criminalizing a plant. And so I always want to start off with, that's where my stance at, that this is a plant. And at one time you could just see cannabis just being grown anywhere, like it would just grow. Hence the slang word of the word weed, because the weeds grow anywhere. Same thing with cannabis, they just grow. And so we are at a place right now where issue 2 has passed and the people have said that they agreed to the terms of that. Now, what most people don't realize is that because of that, some things have become completely legal. Like if somebody wanted to go outside and go smoke, you can go legally smoke, technically. There's no place to buy cannabis. There's no way to grow adult use cannabis. So people can only buy medical use. And I'm only saying that just to lay the foundation of certain things because some people don't even realize what's going on. What we're dealing with now is that even though the people have spoken with more than 50% of the vote of what the terms are, the General Assembly, which is what I belong to, the House and the Senate, is making these new rules on what they think is best for the people. And so what we have originally with House Bill 86, that bill actually started out as a liquor bill. It was a bill that I and many of my other colleagues voted for. When it got over to the Senate, it was like a bait and switch. You voted for a liquor bill when it came out of the House, it went over to the Senate, and then they added all these things for cannabis. Hence, you're seeing what's happening with House Bill 86, which has it doesn't have social equity. So even when we talk about criminal justice has to do also with social equity. It's rectifying some things that we have not really taken care of that, but it also includes expungement. So House Bill 86 includes expungement. The House version, which a lot of my colleagues on the House side contributed to, which is House Bill 354, which also includes social equity and expungement, and it also allows home grow. House Bill 86, which is the Senate version, does not allow home grow. And I'm going to bring it to point why all of this has to do with criminal justice. First, when we talk about expungement, the details of how we do expungement is very important. Legal Aid made a wonderful pride that if we are going to be doing expungement, they need to be able to receive some of that money because there's going to be a surcharge of people who are going to need legal services to have their expungement taken care of. That is not addressed in House Bill 86. House Bill 86 does allow expungement, but it does not allocate money particularly to services such as legal aid within the state of Ohio. We have to address that. We also have to address how expungements are going to be done. So when we talk about expungement, is it going to have to go through a process where people are going to have to literally go to the courts, or is it going to be an automatic expungement? These are the type of questions that the General Assembly has to answer. We have to make sure that people feel seen in the process of government, making sure that, and I personally am advocating as a state representative for automatic expungement, that people do not have to go through a rigid process of getting their things expunged because we want people into this new marketplace. Imagine being the neighborhood guy who's been selling cannabis your whole life. You know this plant like the back of your hand, and all of a sudden, because of prior crime, you're not able to be in this process. We need to get those people up and working. They are the subject matter experts in our community. If you knew somebody that was back in the day selling it, we need them up and working. We need them having their things expunged, but we do not need the system to be a barrier. Also, when it comes to House Bill 354, it allows home grow. And the reason why this is so important that we discuss what happens with home grow, it was an issue 2. And that was another key reason why we had so many younger people who were very pro issue 2 because they wanted to be able to have home grow. House Bill 354 allows home grow. If that is not done in some form or fashion of home grow within the state of Ohio, you're going to be recriminalizing people for just something else. Because I do know for sure people are going to get the seeds they need in other parts and other states, and they're going to bring it to the state of Ohio. So instead of us trying to, stop this, we need to figure out how we can monopolize off of this new tax market within the state of Ohio and help people come up with healthy, safe ways to do home grow. And this is one thing I was telling somebody. My friends were telling me like, oh, I'm so excited about home grow. And then another lady at my church said she's scared about home grow because she's scared her neighbors are going to be doing home grow. I said, ma'am, how many people grow tomatoes? How many people grow potatoes? Everyone has access to seeds here, and we're an agriculture state, but you don't see every neighbor around you growing stuff. So I really doubt that it's going to be a surplus as many people as people think that's going to be growing cannabis. Because one thing we know is not easy. It's not easy to grow. So those are some of those pressing things that we are having to address. And it all has to do with the criminal justice system of making sure that people feel seen and that the process is working for the people. The moment we go against issue 2 as a General Assembly, all of us have a primary in March. And if we go against the people in the state of Ohio, I don't expect any of us to get reelected because we are not going for what the people want. And I know sometimes people feel like they know best when it comes to people, but the people who know best is the people who got me here elected. And the people who voted for that said that they want those type of provisions within that. Just wrapping up with my statement, we have to use issue 2 as the base, the foundation for what we do. We cannot do anything against what issue 2 is. And I will say within the House, we are being very respectful and mindful of what the people want. The people know best. So even if we feel like something else is different, and I don't always agree with everything, but the people know best. Every state House seat, every Senate seat, except for 2, passed issue 2. We have 99 House seats in the state of Ohio. Everyone except for 2 House seats passed it with more than 50% in their House district. So what does that say to us? That if we go against issue 2, we are going against the same people that elected us to office. My name is Juanita O'Brien. Thank you so much for letting me make these opening remarks.
Thank you so much, Juanita. Representative Brent, and I want to really focus a little bit for the time being, get us started with a real drill down into some of the record relief expungement issues that a number of you touched upon in our conversation, but that I think is perhaps particularly useful to kind of unpack a little bit more. And I'm gonna sort of pose this question to you, Adrian, first, but then open it up to others to sort of speak to, both because I think you probably have a sense of the national perspective, and especially with Representative Brent mentioning that she's advocating for automatic expungement, or what I think you call state initiated expungement. And that's, I think, I know Lou Tobin's right to say that Ohio has fairly broad record relief provisions. I'm looking at the Collateral Consequences Resource Center's most recent 50-state comparison, and brag on their work, because they really do incredible work on record relief and the consequences of convictions. And they have Ohio categorized among 17 states with broader felony and misdemeanor relief. But then you go to the states that have provided for automatic record sealing, and Ohio's not there. And that there's only 9 states that have done that. A lot have done it in conjunction with marijuana reform. And so that's become kind of the leading edge of efforts to do automatic expungement, or what you called state initiated. I'd both kind of like you to speak to that vision, and where I sense that advocates are eager to push reform, particularly in the cannabis space after legalization, is to do automatic, and maybe even just explain what that means and how that functions. And I know on top of that, and I want to plug some more of our center's work, Yana Herdnova in particular produced a report a little less than a year ago called "Is Expanding Eligibility Enough? Improving Record Sealing Access and Transparency in Ohio Courts," that emphasized a topic that actually has been highlighted by research around the country and other states as well, that we have what's often called a low uptake rate, that even if you have broad eligibility, absent having some particular mechanisms to ensure people take advantage of these tools, a relatively often a very small percentage of folks actually benefit from having the possibility of their records sealed. And so my sense is automatic expungement, automatic record sealing has been an effort to address that. Can you speak about those trends generally, what you've seen in other states? And then I think the last question is a long question, I know, but hopefully everybody else is taking notes as well. Does that solve all the problems? I've heard stories. There was actually a recent commentary I saw that said it's one thing to automatically seal a record or expunge it, but if people don't know that they've gotten this relief, or maybe they don't believe it, an awful lot of the challenge here is people don't trust the system. And so even if they get a notice, oh, your record's been expunged, maybe they still have to report, or feel they have to report on a job application that they have this past conviction, so on and so forth. And so, not just the question of the move from petition-based to automatic sealing efforts, but whether that's even enough to really have an impact with these kinds of reforms.
Yep, I'm going to try and hit all those points in the most efficient way I can. I think you're setting up a really important distinction here, and I would agree with Lou in the work of the Collateral Consequences Center that you actually just cited, that in terms of its peer states and nationally, Ohio does actually have some of the most robust access to eligibility in terms of who's actually able to seek an expungement or sealing, depending on the variations in state law in Ohio. But there's a very critical distinction between eligibility and relief. And we've seen multiple states, and this is true for Ohio as well, the uptake gap, as you said, Doug, right? As you increase in eligibility, it actually doesn't increase the amount of petitions that are filed oftentimes. So the key research on this is actually done from the University of Michigan in the state of Michigan, which analyzed the of all the people who have met eligibility criteria, right? So this isn't only just the waiting period, right? So the amount of time that the person's been conviction free, you've paid your fines, all those sorts of things. How many of those people actually get expungements? And we've seen in that research that it's less than 6.5% of individuals, right? So if you're increasing the funnel of individuals who might be eligible, it doesn't actually increase who gets through that funnel. And I think that's where automation, specifically state initiated, the concept being that the state has some sort of onus or responsibility to initiate that criteria for individuals, right? So conducting that first sort of step of are you eligible and then granting that relief is really a great sort of leveler in that aspect, because it does actually ensure not only that that person's eligible, but they're getting relief. And so what we really want to see is the migration to a system where people aren't opting into, or specifically, where relief is mandatory as opposed to optional for individuals, and the notification becomes the problem. And we found ways to solve for this. One of the bills that we passed earlier in Last Prisoner Project is in 2021, we introduced AB 1706 in California. So California was one of the states that did do state-initiated expungement for individuals with cannabis offenses. What we did is augment that law to ensure that there's data transparency reporting requirements, and those are posted monthly on California's Department of Justice website. So you can track in real time how close each county is getting towards drawing down on those eligibility criteria. And we're seeing that that eligibility pool narrows with every report as the state gets better about implementing this process. And the other thing about that is notification campaigns. So ensuring that government agencies have money to implement programs so that individuals and communities are aware of the fact that they've already gotten this relief, right? So the idea is that we're moving away from the concept that people might be eligible for a system that they don't even know about, to a system where they're already given that relief and they may not know about it, right? And that's really what we want to see with automatic expungements, tied with the idea of notification, so that an individual can confidently go into a job application or a housing application or applying for a Pell Grant and confidently check that box and say, no, I've never been convicted of a felony or a criminal record for cannabis. So there's a couple things I want to touch on specific to Ohio here, which is the updates made to the system in SB 288. I think there's a lot of great language in there, right? But there is still some language in there that would pose an undue burden for individuals who now have what I would consider outdated records, right? And so what we're really seeking in Ohio is parity for those individuals who have records who would no longer generate a criminal record moving forward. And there's some language about this in that bill, right? That low-level records for cannabis convictions, all that sort of stuff, should not generate a criminal record. That's a really great start. Although, as DEPC's work has pointed out, there's not a lot of evidence about what the efficacy of a policy like that is. We do know expungements work. And so there's a way to already lean on systems that can already exist by connecting the thresholds that can be broken down by building an automated system to move around those processes. So I think that's one of the things that we'd really like to see in Ohio is cannabis convictions being that building block that can lend itself to a larger system to include other offenses that could also become eligible for a state-initiated system.
Thank you, Adrian. And I'll now turn to our Ohio experts and particularly open it up, but especially Daniel and Lou, eager to hear your perspective on conversations about automatic sealing or expungement, given that Ohio has this non-unified court system. We have often struggled to statewide anything, and let alone something that has a range of intricacies to it. We've seen in a number of other states that have automated record sealing and expungement, not just the devil's in the detail, but it often requires a very significant investment of resources to kind of make it happen, especially if it's going to come with an information campaign. And so just love either of you, both of you, to talk about, kind of what you see both as the possibility and the potential pitfalls of a move towards an automated process. And then Representative Brandt, I'll certainly, have you chime in, because I'm sure you've thought about these things as you've been advocating for an automated process in this context.
I'll go first, Dan, and maybe you can follow up. But I've got serious concerns with the idea of automated record expungement and even state-initiated record expungement. We were not fans of the language that was included in Senate Bill 288 that created prosecutor-initiated expungement. And there are a couple of reasons for that. One, prosecutors simply do not have the resources or the time, quite frankly, to go sifting through old records to determine who's eligible for this and to submit those applications to the court. Prosecutors statewide are dealing with, and these are just felony cases, you know, almost 100,000 cases a year, I think we're up to. And we just do not have the staff and the resources to go sifting through those records, particularly if you're looking back over a certain amount of time to determine who should have their records expunged. Secondly, I think there's value in having people come forward and saying that they want their records expunged. We shouldn't require prosecutors and courts to use their time for people who might not care. I think we can make that easier for people. We can streamline it, but we want them to come forward and we want them to demonstrate that this is important enough to them for prosecutors and courts to use their time to expunge or to seal the records. Three, I have issues with automatic expungement because I think there's value to having hearings on these things. Judges are not infallible. I think prosecutors will tell you that even today they have hearings on applications for sealing or expungement where the prosecutor will point out something in the person's background that indicates that they're not eligible to have that record expunged or sealed. You lose that if you do away with the hearing, and I think you're going to wind up with records that are expunged mistakenly. You could wind up with records where there was a victim expunged mistakenly. There are problems under Marcy's law regarding that. And so, there's just value to having a hearing and to having some of that stuff fleshed out in an open setting in court.
And I want to make one more plug, Dan, before I kick it to you, that for some research that our center has done last August, we released a report called Prosecutor Initiated Relief in Ohio, a survey of prosecutorial plans to seal and expunge low-level controlled substance offenses. And it was basically an effort to figure out, as you were suggesting, Lou, whether prosecutors would be interested in the opportunity that Senate Bill 288 presented for them to initiate. And we found in a survey of local prosecutors that only about 12% of respondent prosecutors indicated they were going to pursue prosecuted or willing to pursue prosecutor-initiated sealing. And the explanation for why others weren't were largely commonly not having the staffing resources to do this, lacking of financial resources to do this, lacking the data needed to do it effectively, and then also believing the system that's in place for defendant-initiated sealing was sufficient. And so, just to put a little extra data on your commentary there, very much seems to reflect what our survey respondents said concerning why the prosecutor-initiated approach was unlikely to be used significantly. All right.
If I could just add one thing to that, Doug, before you go to Dan, only about half of my members, half of county prosecutors, even have misdemeanor jurisdiction. So a lot of these, in a lot of counties, that the prosecutor-initiated process would be handled by a municipal prosecutor who handles the municipal cases there.
Yeah, so I'll just add a few thoughts. First, Ohio is not the only state without a unified court system that has moved to the clean slate model of legislation with automatic sealings. And I think that one of the ways that you could possibly do that is have set it up so that the Bureau of Criminal Investigations, BCI, within the Attorney General's office, could on a regular basis send to the courts those offenses that are eligible for sealing. As Lou noted, though, it will take additional time for prosecutors and judges, but I don't think that means that we shouldn't do it. If it takes more resources to get more Ohioans back to work, then that's something that the General Assembly should definitely look into. And I, whether there's value in people stepping forward, I think I think that's a good point that Lou has made. The problem is it's just so difficult to do. Like I said, I've done these before, and And, even as an attorney, it's something that I've got to spend time on and think about, because it's not something that I do regularly. And so, I know that we're not talking about certificate of qualification for employment, but Ohio has this other program. The General Assembly is always trying to give these additional opportunities. And if you look at that program, so basically what it does is it creates an exemption for disqualification for occupational licensing. So even somebody with a criminal record can still get the occupational licensing. It's a great program, but if you look at where it's utilized, it's around a few law schools in Ohio where they have student groups who are helping people with that. So they're great programs, and it's fantastic that we're doing that. But as Adrian noted, making sure that it's accessible to people is really important. And it's difficult to see how to do it in another way other than making the process automated in some way.
Thank you, Daniel. And Representative Brent, I'm sure you've given considerable thought to these issues. One point that was brought up in the Q&A that I wanted to just sort of flag is that there have been some private groups, Code for America, I think most notably, that have been actively involved in trying to help states deal with automatic expungement. I know they've done a lot of work in California. I don't know if that's a group you've interacted with at all, or whether, in addition to hearing your take on advocating for automated processes here, what your sense of the role not just of government is, but of outside agencies. I'll throw in research universities and the like, because it does seem at times to be an all hands on deck type of endeavor. And so sort of with that, I'd like to give you a chance to talk more about your advocacy for the automatic process and your vision of how that can work in Ohio.
Thank you. I just want to clarify some things for those who are hearing terminologies being put out. One particular thing is when you talk about Marcy's Law, particularly Marcy's Law is dealing with the victim's right to be present and heard. We're talking about cannabis convictions that are talking about dealing with a plant. Talking about a victim and a plant is two different things. If you're selling something, if that's for a different charge, then that's totally different. So I'm not a lawyer. Lou is, he's a prosecutor. So I'm not trying to undercut him, but we're talking about cannabis convictions. If there's a situation when it comes to a victim, then that's a different type of crime from my understanding. Lou, get me together if that's not the case. Don't get me together right now because I'm not done talking and I let you talk. So that's one. So particularly when it comes to Marcy Law, if that's the case, then that should be present. Those are those exceptions. Those are always exceptions. There's always exceptions to people who have to deal with situations of getting things expunged or sealed within their situation. Also, too, when our prosecutor also talked about his support of House Bill 86, which is the Senate version of adult use cannabis, a lot of that money that's being put for taxes in particular are going for law enforcement training. If we know we need more staff hired, more help when it comes to our prosecutor's office to do expungement, then our money needs to be reallocated to help with our process for our prosecutors to make sure we can have more expungement. If this is what the people want, then we need to adjust where the money is going to give people what they want. And the people say that they want expungement. People say that they want all of those type of things. People want government to be accessible and to be easy. To have people to take off of work, use the bus system, which we don't properly fund, because in the nation, we are 45th in the nation when it comes to funding public transportation. So you're expecting people to get to court off of a bus system that's not even being properly funded within our state. So that's one thing, because I don't hear anybody advocating for public transit, but you want people to have to physically go into court. Two, particularly when it comes to all of that, we are dealing with people who already have a current conviction from a job. They probably working like an hourly job or some type of job where it's going to be hard to get off. And we don't have automatic access to people having paid time off just to go to court. There are states that are allowing people to do it. If you have to go to court, you automatically get the time to be able to do that. Ohio is not one of them. So that's already those different type of barriers that people are dealing with here within the state of Ohio just to get access to go to court. I mean, it's not easy. And let's not even talk about the unaffordable childcare that you might have to take your child into childcare. And we as a state have not addressed childcare when it comes to all of that. All of those things come as a barrier when it comes to people just getting to court. Two, House Bill 86, which the prosecutor is championing for, is not giving money to our legal aid. If somebody's going to court, they're going to need a lawyer. You're going to need some type of legal representation because other things may come up. You don't know how to get through the process. How can we work for the people? It's always an excuse on what we can't do, but what we can do is reallocate this money and make sure that people have access to it instead of giving all of this money to police training. It blows my mind, particularly how much money they want to put towards police training within the state, particularly for House Bill 86, which came out of the Senate. To me, it's ridiculous. People have told us time and time again when issue 2 was passed what they want. All we're doing right now is going against the people's will. And I don't know how to, Lou, were you elected? Yes or no? Were you elected to office? No. So you weren't elected to office. I was elected to office. So I'm not about to go against the people, the state of Ohio. And it's easy for somebody to come up with rules when they were not elected by the people who put this in place. And that's for issue 2. We have to stand by the voters in the state of Ohio. Hold on, Lou. I see you getting etchy. And I let you talk. You interrupted Dan. You're not going to interrupt me. So you're going to wait. Thank you. So also, there's a value of people coming in that care. Anybody that's been convicted, you can't tell me somebody does not care about their conviction. It's almost like a slap in the face to say that people don't care because they received a conviction within itself, and the value of having hearings. Like you said, our courtrooms are already inundated with a lot of court cases. It's hard to even get a basic traffic stop ticket because you got to wait because of what's going on within our communities. Now you want to add on something more for these convictions when our judges are already telling you they're inundated with all types of trials, court cases. Our local public defenders are swamped. So are our prosecutors. Give them the money so they can be able to get this done. Let's allocate, Lou, let's work on this. You and I are going to work on this because I'm going to follow up with you. We're going to work on allocating this money in House Bill 354 because y'all weren't trying to do that in House Bill 86 with the Senate. We're going to work on making sure the money goes to support this necessary staff we need to have so this can get done. If it's a staffing issue and we need money, we need more people, to allocate some money so we can hire some people. It's a lot of young people who are, dumb they didn't pass the bar and they need a job at the prosecutor's office. They're in their first year after they pass the bar. Let's hire those people so we can get it done. Let's not make excuses. Let's make goals and make decisions to take care of Ohio's people. I'm done, Lou.
Okay. Well, first of all, I 100% would love to work with you on that, Representative Brent. Just a couple of things. My point about victims is only this, is that, sometimes a marijuana conviction is tied to some other sort of conviction. It could be tied to child endangerment, to domestic violence, to some type of assault. And what I don't want is for a judge to mistakenly expunge a marijuana conviction and these other convictions that are tied to the marijuana conviction behind closed doors. I want that to be done in open court where any issues can be brought out. But in terms of funding for prosecutors' offices, one of the things that I have asked for that the Senate did not include in House Bill 86 is help for prosecutors' offices just in general staffing needs. We desperately need money for victims advocates programs in prosecutors' offices. We desperately need money to help us hire assistant prosecutors. So to the extent we can work together on that, Representative Brent, I'm 100% on board.
Now, what I'm for real quick, thank you, Professor, is giving money to things that's not related to cannabis. So I know people get real excited because they like it's new money. I'm treating this like it's old money. If we get taxes off of anything else, we're not using it for everything underneath the stars. If we have to use money towards legal aid with our prosecutor's office to help people and everything else, we need to intentionally make sure all of this money is going towards cannabis and cannabis alone, not helping victims of other things, which, hey, I've been in that situation myself. We do need more people in that space. But we need to first make sure that we are addressing what we are starting with, and that's adult use cannabis and everything that is involved with that too. So thank you.
And so thank both of you, very respectful and engaged dialogue, which is exactly what we welcome and want to make sure we do here. And in fact, that conversation, especially about funding, I think is a perfect bridge to the sort of somewhat broader question I want to engage, that I want to stay kind of leaning on the criminal justice piece. But I think particularly Representative Brand, a lot of your earlier comments kind of highlighted how challenging it can be. And even Lou, some of your comments as well, to sort of segregate the criminal justice side from the everything else about regulations and everything else that we're doing in the cannabis space. They necessarily fold into each other and overlap. And against that backdrop, I want to remind folks, and this is currently the law in the state of Ohio, and one of the commenters highlighted that we're dealing with the text of issue 2 in part because the General Assembly wasn't able to move forward with reforms as this was in front of them for more than a year, and as you know, the will of the people has been suggesting affinity for cannabis reforms. Ultimately, we get this written proposal that's the only thing that voters can vote on, and they vote in favor. A big part of that proposal involved the allocation of tax revenue, specifically more than a third of the expected funding to this social equity and jobs fund. And though, again, I don't want to talk about, though it certainly is worthy of discussion, the full range of social equity issues that necessarily engages, I want to read the exact language of what I see as sort of the main criminal justice piece of the instructions for the allocation of those resources. Specifically, it says, study and fund judicial and criminal justice reform, including bail, parole, sentencing reform, expungement and sealings of records, which we focused on, legal aid, and community policing related to marijuana. And to me, I was struck when I first read that language in issue 2 as a proposal. It seems to cover the entire criminal justice system, right? We're not just talking about how to deal with past records. It's looking at something that we have seen, an array of areas where even once you've legalized cannabis, you may have a judge at sentencing saying, I'm not going to let you use cannabis on community release, or that bail or parole might be impacted by a past conviction, even one that might be subject to some kind of record relief. The legal aid part, of course, funding for the lawyers to be involved in this kind of work can be so essential. And I'll, at the risk of being a broken record, plug another study that we've done at the Drug Enforcement and Policy Center. We estimated, the tax revenue that would likely flow from adult use legalization with just the tax rates that were set in the initiative. And our numbers came up once all the stores are up and running to, a conservative estimate of $250 million per year. A third of that would be, a pretty darn significant amount. There are other things listed as priorities to spend that money on as part of the social equity and jobs fund. But I guess I would just sort of like to hear from any and everybody, what other aspects of criminal justice reform related to cannabis. And again, it may be it's funding to prosecutors. I don't see that on the list, Lou. I'm sorry, but nevertheless, it might rightly be part of, it does actually say study and fund judicial and criminal justice reform. Certainly our non-unified court system could use some resources in a variety of ways. And so I guess, maybe I'll frame it this way. I've come to you with the bank full and the checks blank, but we have to devote it to something that's consistent with this language of judicial and criminal justice reform, including bail, parole, sentencing reform, expungement, legal aid, and community policing related to marijuana. Where are you going to use those dollars? Where do you think we may have gaps, either in Ohio or Adrian, if you want to speak to this sort of nationwide, that we're underfunding or just failing to pay attention to in the cannabis reform space, that this kind of expansive language might give us an opportunity to look at and address? And I actually have a little bit of an answer to that as well, but I'll save that for the end until others jump in.
Sure, I think I'll start there, and I think it's an acknowledgement of where Ohio enters the conversation in this already, right? So as you said, the language in issue 2 says to study and fund these things. The reality is that there are 24 states that have already studied and funded these things and have empirical data about how well these sort of criminal justice and criminal legal reforms are working in conjunction with legalization. So there are lessons to be learned for Ohio in those specific examples. And I think Lou actually acknowledged, at least tacitly, one of the ways that cannabis sort of ripples through the criminal legal system, right? Which is that it is often the seed that allows the carceral system to sprout up around individuals. So in the example that you brought up a little bit earlier, right, is an individual who has cannabis that also gets ensnared with the child endangerment size. Part of what we do at LPP is actually represent constituents who are going through the legal system. And this is the thing that we see commonly, which is why we push for sentence modification, which is inherently involving sort of judicial discretion to make those sorts of decisions on individuals, because we can see how a cannabis, what starts off as a sort of simple cannabis conviction can ripple and really affect an individual's life because it's compounded by additional charges that get onto them. So I'll just briefly say this happened to one of our constituents in a different state who had cannabis in their house, but it was within the or it was in a school zone area. So then the child endangerment hit, all sorts of things. And so those were where we actually do believe judicial discretion should play a role, because it's the only way to untangle sort of all the ways that these layers stack on top of one another. So that's one thing right there. I do think that there are other lessons that can be learned from this, especially in a non-unified court system. As Daniel said, states have been able to do this in non-unified ways, especially around cannabis. Illinois is one of the states that does not have a unified court system that has been able to actually implement a state-initiated process for specifically cannabis records, and that results in about 700,000 convictions cleared. The other way to think about this is, yes, it's going to take revenue to generate these sorts of systems that provide the relief incorporated in state-initiated sentences. They also generate revenue for states. Empirical data from recent studies demonstrate that after 5 years from getting record clearance, individuals are less likely to recidivate and they're more likely to be employed. This was actually one of the main reasons that Utah became the second state to actually adopt automatic record clearance, because the Chamber of Commerce saw it for what it is, which is an economic development engine for individuals to actually re-enter the workforce or go back to college to earn that advanced degree that allows them to make more money and contribute more taxes to society. So there are ways to implement these programs that are not only compatible with public safety, they're actually implementing and encouraging greater returns on investment for individuals who actually enact these. And then the last thing I'll say really quickly is to invoke the national dialogue and what that might mean for Ohio, as Doug said, is there are other sort of tangential reforms that necessarily involve cannabis or other drugs that should also be on the table. And so one of the things that we're seeing at the national level is the conversation around rescheduling cannabis to Schedule III, right? That's where it is, and we've written extensively about how we can do this. And I think one thing that should be considered on the table, or at least two things that should be on the table for Ohio, is technical violations for individuals who are on parole probation. We've seen other states that have legalized cannabis actually tackle this and say, if you have a valid medical license, perhaps you should not be recidivated on parole or probation if you're using it within the confines of legal law. So that's one thing I would consider. Two, as states are sort of gearing up to initialize a legalized market, especially over a long duration of time, I would encourage the state of Ohio to enact laws that protect individuals who are stuck in the gray market. So you have individuals who are entrepreneurial and want to get into the marketplace as soon as possible. They are starting to stock products so that on day one of launch, they are actually able to meet consumer demands. They are in violation of the law, as Lou said, right? Every state that has legalized cannabis maintains penalties for cannabis. And sometimes you might unintentionally break that law by making sure that your product is stocked for consumers to use. And you are now over the legal limit of what's considered a felony possession of individuals. So I would encourage the state of Ohio to consider protections for those individuals, that so long as you have a license to operate as a potential distributor in the state of Ohio, you are exempted from those unintentional penalties as they're happening in production or in ramp up to legalization market.
Other thoughts about broader criminal justice?
Yeah, I can go. I think that the unified court system is so important. It's something that would be so useful for all the things that we do in the criminal justice system. Professor Berman, as you know, it's hard to get data on criminal justice issues, and it's because we have 88 different counties, and they're using 20 some odd different systems, and it's actually a public safety problem, because you can have somebody who is out on bail or on probation in one county, and they get picked up by police in another county, and because our systems don't talk to each other, they may not know that this person has a warrant out for their arrest somewhere else. We just don't talk to each other. And then when we're talking about changing the criminal justice system, we're going off the best guesses that we can make, and we're going off of the anecdotes, which is not great. Go to any hearing at the State House where they're talking about particularly increasing penalties, and you'll hear this really horrific story, which is terrible. And so we try to increase these penalties based off of that one story, but we don't really talk about how it was the subject of a plea bargain, and the person did get out sooner than they probably should have, and things like that. But we're not able to collect all the data to understand which communities these policies are impacting the most, or which crimes are being committed, how are they being charged differently and sentenced differently in different communities, and what is the outcome of that. And so I think that just for everything that we do, getting a unified court system and data collection is so important.
Oh, I just want to piggyback on that really quickly. So Daniel's absolutely right. And I think that's the opportunity that cannabis presents to Ohio. I guarantee you there's a cannabis charge in all of 88 counties of Ohio. It is a through line that's going to be consistent through all data points across the system. So what would it look like to then leverage that system to build these unified court systems and then expand on it so that you do have access to these more robust data sets? So one thing I'll say very quickly is that in our implementation work with other states, what we've learned, and I understand, is that agencies are concerned with compliance. Give me the law, and how do I make sure to check all those boxes to ensure that we are compliant with the law? They're not necessarily focused on ensuring greatest eligibility or making sure that individuals actually take use of that. That's one of the things that automatic record clearance could actually improve. And what we're doing is simplifying that process by following the through line that cannabis creates across all those 88 counties to say, where is that data actually existing and it's just in a silo? And how do we build those connections to have a unified roadmap that draws towards the common goal of making sure that individuals not only are eligible for the relief, but they're gaining that relief?
I'll just say, if you came to me with this pot of money and asked me what I could spend it on, I'm not sure that what I would spend it on falls directly within the guidelines of what was in issue 2. I do like the idea of spending money on law enforcement training. I think we can all agree that we want well-trained law enforcement in the state of Ohio. I think this is a great opportunity to use some of those tax dollars to make sure that we've got the best trained law enforcement in the state of Ohio. Obviously, I do like the idea of providing some funding to prosecutors' offices to hire staff. There is going to be increased responsibilities placed on what are already understaffed prosecutors' offices across the state of Ohio. And the last thing that I would plug, and this is kind of a niche issue, but it goes back to my concerns about an expanding black market, is that we've got a bunch of canines in the state of Ohio now that are trained to hit on marijuana, and some of them might be able to be retrained. There's a little bit of a dispute right now about the viability of the canines that are already trained on marijuana and whether they can continue to be useful without being retrained. I think they need retrained, or that we're going to need new canines across the state of Ohio. And marijuana, some amount of marijuana is legal, fine, but we still want to conduct successful drug interdiction efforts on other drugs, marijuana or heroin, cocaine, certainly fentanyl. And we're going to have to fund new canines across the state of Ohio to do that. I would like to see a portion of the tax dollars from marijuana go to buy new canines.
Well, I will not be the one that tries to undercut a jobs for dogs program. So, it sounds good to me. Go ahead, Representative Brand. I don't know if you want to speak to that. You actually get to decide where money goes, or at least with your colleagues get to do that. So maybe speak to this, and then I tease the idea that I have a thought. Daniel kind of got me started on that, but go ahead, and then I'll chime in, and then we'll have time for some final comments.
Thank you. So one thing, and I was just listening to everyone, and I was taking down notes and making sure we have to take in the data as we are going through this process. I know one of the questions that came in the chat about how we expand this is about the difference between having a unified court system and not having a unified court system. I think we are a big state that's big on local control. The moment you start talking about unified court systems, you take away the possibility of local control, and then everything goes up to a higher system of who the judges have to, kind of like what they call the administrative judge. There would be a different form of what an administrative judge will look like. You will have a state form of it. And depending on how you feel about our states, you may or may not like having a unified court system, or you may like it when it comes to us particularly having an easier process to do expungement. So that's a bigger question about having a unified court system or not. I don't think talking about cannabis is the time to determine if we want to become a unified court system. So it's not to take away from the questions that are in the chat right now. But I think that's a bigger question that I don't think Ohio is ready to have. If you ever want to see a fight, talk about the court system. You'll see a fight right there if we're going to do that or not. But data is a necessity. And so, but even when you do data, it takes money to collect data. It takes money to keep the data, to have the resources to also make sure there's a report. Anytime there's a report that's sent out with data, it has to go to the General Assembly as well as to the governor. Who's going to put out the report? You got to pay somebody. You need money for that. So all of these things cost dollars. Also, particularly when it comes to, police training. I'm still trying to figure out where does that come into all of this. I know House Bill 86, which is a bill I would have not voted for if it came over to the House. It's giving, $80 million for jail construction. I'm confused on that. Also giving $15 million for a drug task force. I mean, it's if we know cannabis is being legalized. I mean, so some of these things when it comes to just what House Bill 86 in particular wants to do for the tax revenue is stuff that I'm kind of almost cringing on. There's some good things in there. It's $15 million in there for marijuana expungement. But to talk also just to get away from the tax revenue for a hot second, to talk about our canines, yes, we are going to have a problem here within the state of Ohio. We have 298 dogs that would need to be replaced because of issues 2's passing. Don't ask me how I know. Shout out to Representative Brennan, who has a bill that's about to be coming out. And it's going to take us about $6 million to replace all these dogs. It's $15,000 to $20,000 to replace one canine here within the state of Ohio. So we have to come up with a plan because a lot of our municipalities will not be able to sustain that cost if they only have one dog within their unit or 2 dogs. That's a hard hit on our local municipalities. So since we know we're going to have about $200 million, having money for canines should also be part of this tax revenue for this new booming side of things going forward, since there are going to be municipalities that are going to be losing a dog. So between that and actually trying to grow the necessary amount of dogs, 298 dogs is a lot of dogs that we need within the next year to help replace all the dogs that are going to have to be retired within the state. And that is about $6 million total on the low end. Just like we need at least $6 million for that to occur here within the state of Ohio. We have to address that. That has not been addressed within House Bill 86 or House Bill 354. And that wasn't addressed either with issue 2 about that direct money for canines. But we know when one it causes another effect within that too. Also too, and it keeps on coming out with the statement of the black market. For one, I hate for us to even bring that up when we say the black market, because it's always going to exist. There are people right now who are secretly selling their tomatoes. There's people who are secretly selling their corn. So, and I know we're talking about cannabis and somebody's like, why does she keep on bringing about other produce? Because there's always going to be a black market for something. Those people are going to exist regardless if the government has it perfectly set up or not, and it's going to expand. And there's been a market, and I'm just going to say there's been an illegal market of this going on for decades. But the ones who've been disproportionately been affected by that have been people of color within our state. So how do we help our state deal with that, about giving back to the communities who have lost tax bases of people who've been convicted by crimes? That's what we have to really be concerned about within our criminal justice system as it expands. So one of the things, and I talked about this at my press conference, of Cannabis for the People, is making sure that communities that have lost a tax base of people who've been convicted by cannabis crimes are being poured back into. And so I would say, no, if you look at House Bill 86 or House Bill 354, neither one of those bills address that, about communities that have been disproportionately affected by loss of tax revenue because of people who receive cannabis convictions. And that's how we have to look at it. If your community has 100 people, the next person's community has 100 people, but the people in my community have had 25 people who have all been convicted of a cannabis crime and have had to go serve time, that's a lack of tax dollars that we have lost within our community. We need some money to pour back into those communities that have disproportionately lost tax revenue because of the people who have committed those actions. So we got to figure out, like, how can we make a full circle of all of that. Thank you.
Thank you so much for Representative Brand. That's a perfect way for me to jump in with to note the fact that the current language in Ohio law, because of issue 2, also calls for the Job and Equities Fund to study and propose policy reforms to address the social and economic impacts of the enforcement of marijuana laws, exactly what you were sort of talking about in terms of the economic impact. And yet, as you mentioned, and as I think has been discussed throughout, collecting data, doing this analysis is not cheap. And I say this with my own bias. I teased it before. I think Ohio is often somewhat teased as always being good at being the 20th something state to do something. You know, we're pretty good followers. We're not always at the last, but we're rarely at the beginning. But I do think when it comes to data collection around cannabis and cannabis related topics, we're at a moment where we really could be leaders, because especially in the criminal justice realm, now I'm on my high horse. You know, we have some decent but not great data on arrests. We have almost no data on convictions. We have no data on sentences. We have no data on the intersection between cannabis arrests and other offenses, convictions, so on. The case processing that cannabis has been a part of for so long, not only with respect to other drugs, but other crimes. Another topic that I saw came up in the chat was, you know, how are clearance rates impacted with police no longer needing to arrest for cannabis offenses, but then, you know, having other responsibilities and challenges in this space. All really important topics that is why we could have gone another 5 or 6 hours for sure on this, but we are already out of time. And I hope all of you felt as though you got to speak your piece and get those first thoughts out there. This is recorded, and we will be cleaning up the transcript to post it on the Drug Enforcement and Policy Center website in the coming days. And I just hope all the participants will do a virtual clap to thank our panelists for sharing their wisdom here. I also hope we can have all of you back, whether it's, you know, after the General Assembly doesn't pass something or does pass something in this space. There's going to be more to talk about. And so, again, incredibly grateful for your time and energy and insights today. And thanks to everybody for participating in the panel and listening in. I'm going to call us closed, only 2 minutes over time. And again, I look forward to just saying see you later rather than goodbye.